couple times a year, I get calls from people who've been in auto accidents and have settled their injury case with the insurance company and then realized that was a mistake. And they want to know, Brian, what can I do to undo my settlement? So in this video, I'm going to be talking about the very specific set of circumstances that allows you in Virginia to undo your auto accident case. And at the end of this video, I'm going to tell you the ways in which insurance companies try to make an end run around this statute and try to bulletproof their settlements so that you can't take them back. So let's start with this. There's a very important principle of contract law, and it's called no take-backsies. And what it says is, if somebody's made you an offer and you've accepted the offer and you've received something of value for the offer, then you can't take it back. So here are the criteria that you need to meet in order to undo your auto accident settlement in Virginia. Number one, you have to have settled the case only within the first 30 days after the crash. And the idea is this: in the first 30 days, there's a whole lot of stuff going on. You got medical care, trying to figure out the legal system, you might have some financial difficulties, and the legislature has put this statute in place so that if you make a mistake in the first 30 days, you can undo it, okay? If you're 60 days, 90 days, a year into the case and you settle with it, we assume that you had enough time to figure it out and that if you settled the case, you actually meant to settle the case. So you have to be within that first 30-day window to do what I'm about to tell you to do. If you settled your case within the first 30 days after the accident, and you are within 3 business days of signing the release, you can rescind your settlement. You can undo your settlement. And you have to send something to the insurance company in writing to be able to do that. You can't just call the adjuster and say, I take it back. Okay? You have to send them something in writing, and the best advice I can give you is to send something that's trackable in writing. Don't send a letter, right? Because letters get lost in the mail. We have no idea when you actually sent the letter. Send an email. If you still have one, send a fax. Maybe your insurance company is set up with texting, send a text. And then confirm that the adjuster received it. So you must send something in writing within 3 days of signing your settlement release, which must have happened within 30 days of being in the crash. The last criteria is that you cannot have had a lawyer. Again, the idea is that we want to have final settlements. We want the insurance company to be able to close chapters in their insured's lives. And if you had a lawyer, we presume the lawyer gave you some advice. Either you listened to the advice or you didn't listen to the advice and you signed the release anyway. But you had the opportunity to avail yourself of some advice. And then, so if you did have a lawyer and you settled the case, it's done and over with. There's nothing that anybody can do except maybe sue the lawyer for malpractice, and that's a whole nother video. So again, the rules are, first 30 days after the crash, you can rescind the settlement if you send something in writing within 3 days of signing the release and you did not have a lawyer. Now, I'm going to get into the part the insurance company doesn't want you to know, because this is how insurance companies subvert those rules and make it so the statute doesn't even matter. So here's what insurance carriers do to make it so this statute has no effect. What you often will find at the beginning of a case is an agreement that looks something like this. Within the first 30 or 60 or 90 days, we will pay $10,000 of your medical costs and we'll give you $3,000 for pain and suffering. Now, there's plenty of cases for which that's a good deal. If you're not hurt at all, that's a good deal. If you only have an urgent care visit, that's probably a good deal. But there's plenty of cases for which that is not a good deal. And the thing is that 7 or 8 or 14 days after your crash, you really have no way to assess whether you're going to be done and out of medical care by the end of that time period or not, or whether that $10,000 that they offered you for your medical care is going to cover all your medical bills or not. And so we always advise clients, don't settle the case, don't make any negotiations until you are entirely done with medical care. Because those kinds of deals, even those open-ended deals, are subject to, yeah, that's a full settlement. The court is going to say that's an agreement that you entered into. You cannot undo it if you wait beyond 3 days. What insurance carriers started doing after this statute was enacted is they started settling cases without releases, because this statute only applies to written releases. So they started just making oral offers to people. They said, okay, I'll offer you $7,000 now, and just give me your direct deposit info. I'll put it straight into your bank. You don't even have to sign anything. Sounds pretty good. Sounds easy for you, right? $7,000 shows up in your bank account. Wrong. Because this statute only applies to written releases, and if you get the money and you keep the money, a court is going to say, and a court has told clients of mine before, when I argued this, that that's a final settlement and that you cannot now undo the settlement. So we see insurance carriers kind of going outside of the window of the traditional written release because they know that people make mistakes early in cases. And they know that if they can catch you in one of these mistakes, they can limit their liability, protect their insured, and deliver more value to their shareholders. If you have settled a case, you have to work really, really hard and really, really fast. The last thing I'll tell you is if you've gotten money from the insurance company, send it back. Send it back, okay? It's not an advance on the medical costs. It's not an advance on your lost wages. What you're doing by holding on to that money is exposing yourself to the risk that the insurance company is going to say that was a settlement and that you accepted their offer. And there's almost no good reason to keep the insurance company's money because you're exposing yourself to that risk, and you don't want to get to the end of the case and find out that you don't know as much about the law and the legal system as you think you do. So if this video has been helpful to you, and if you're running now to write your written rescission to the insurance company, I want to invite you to check out some of the other videos on our channel. We talk about how to resolve your personal injury case, when to look for a lawyer, what kind of cases don't need a lawyer, and general legal principles in Virginia. So lastly, if you're going through it and you've decided this is not for me and I need a lawyer's help, give us a call. We'd be happy to discuss your case with you.